Hi, everybody. I'm David Goldstein. I'm the chair of the nonprofit tax-exempt religious organization practice group at the Certilman Balin Law Firm. Thank you for joining us today. Let me start with an apology. I'm sorry that I can't be with you in person as planned. I am instead attending a funeral, but the folks at Cerini were kind enough to let me record this in advance. And I want to encourage you so that we can get as close as possible to what the live would have been like, to please post any questions you have in the chat. And again, our kind hosts at Cerini will get those to me and I will respond to you via email. So it'll be virtually as good as had I been here in person. So let's go. We're going to do an update on some legal and governance aspects of not-for-profit law. And let's start with some simple governance mistakes that we've seen from new clients coming into us recently, coming in with a bit of a mess. And there have been a bunch of really simple mistakes that wound up having disastrous consequences for these nonprofits. So let me give you just a few examples. Inadequate meeting notice, generally of board meetings, but if you're a membership nonprofit, the same would apply to membership meetings. Uh, Flawed election process, procedures, or record keeping, which then opens the door to uncertainty as to who is on the board. So directors are elected to the board. There's an annual meeting every year at which directors are elected. And if there's something that's wrong with the election process, it then calls into question who is on the board and who can make decisions for the organization. Questions as to the authority of an officer approving an action or actions. Did the CEO or executive director have authority to sign that contract? Is a classic example, and we see a lot of that. Minutes, minutes, minutes. Minutes are incredibly important. They are an area that people kind of roll their eyes at. People don't like to read them, even less to write them. But they're incredibly important because they are the record of your organization's actions and proceedings. And if the minutes are flawed, if something is missing, if something is incorrect, then that can lead to a significant problem. And we'll talk about some examples of these things as we go along. Um, Ignoring controlling statutory provisions, including where there's a conflict between a mandatory provision of the law and what you have in your bylaws. And that happens all the time. And when that happens, it means your bylaws are wrong, because there are quite a number of mandatory provisions in the law that the bylaws cannot trump. So when there's a conflict between a mandatory provision of the law and a provision in your bylaws, and you follow the provision in your bylaws, you'll have a problem. And so examples that we've seen of that are provisions around quorum. What's the minimum quorum? Sometimes the statute requires a supermajority quorum. Going back to the minimum for a minute, the statute has a floor below which you can't go for quorum, both board and membership. If you're a membership nonprofit, the statute has mandatory provisions on voting, on notice, on other things like removal of a board member. Those things cannot, to the extent that they're mandatory, cannot be altered by provisions in your bylaws. So that's something to be incredibly careful about. When we see that coming back to bite nonprofits all the time, and that reinforces that the bylaws need to get tremendous focus, and they need to be reviewed by a lawyer, or written, even better, written by a lawyer that practices in the nonprofit law area. Another simple governance mistake that we see causing all sorts of issues for nonprofits is ignoring a controlling provision in the bylaws. So if your bylaws, again, have provisions on quorum and voting and notice that are consistent with the statute, then you better follow them. And if you ignore those provisions, then the decision that you're making will likely be called into question. Another common mistake that we see is ignoring controlling provisions in the certificate of incorporation of your organization. That's very easy to do because it's easy to lose track of your certificate of incorporation. It's literally the first document you file in the life of the organization. It's something that is easy to not focus on 5, 10, 15, 20, 50 years later. But in fact, the certificate of incorporation inevitably must, under the law, contain your corporate purposes, and your corporate activities are governed by those purposes, and you cannot operate outside of those purposes. So as you can see, and again, we're going to come back to this later, the certificate of incorporation and in particular the purposes provision is incredibly important. Seems like a simple thing, but a mistake in this area can be quite catastrophic for a nonprofit. And then something that we see all the time is people coming into us with some sort of either dispute, litigation, could be an internal dispute, it could be some litigation, a dispute that kind of mushrooms into litigation. It could be some sort of regulatory entanglement, perhaps an attorney general inquiry or investigation relating to a controlling provision in the conflict of interest policy that was not followed. The conflict of interest policy, if it follows the required provisions of New York law, is by definition incredibly detailed. It has all sorts of procedures, definitions, even mandatory language that the board has to include in resolutions. So if you're approving a related party transaction, which itself is defined in the statute and must be defined in the same way in your conflict of interest policy, the board has to adopt mandatory language. It's not enough to say that the board approves the transaction. The board has to make a finding that uses mandatory words, and the statute sets forth those words and requires a determination by the board that the transaction is fair and reasonable and in the best interest of the corporation. And further, it's important to base that on some objective criteria. So these procedures and definitions and processes must be followed. We've had a few instances, and one can understand how it's kind of easy to get a little sloppy in this area. Disclosure is so important in this area of the law. And we've had a number of instances where clients come into us, meeting us for the first time and telling us they've got a problem. And the genesis of the problem is that a board member or an officer disclosed a conflict of interest, but did it without the adequate formality and detail. So the board member said, I have a conflict of interest because I own this business, or my relative owns this business, and the organization is going to do business with my business entity. That's not enough. The law requires written disclosure. Again, it requires all sorts of procedures. It has all sorts of related definitions, and with a related party transaction, mandatory language. So if a board member says, well, I did what I had to do, I disclosed the conflict, everything's okay, everybody knew the relationship, that's not enough. So these are areas where what appear to be little faux pas actually hit a fault line and can create all sorts of issues for a nonprofit. So what do all of these governance missteps have in common? They call into question the authority of the actor and or the validity of the action, decision, or expenditure itself. They can lead to incredibly adverse consequences, particularly when weaponized by an aggressive adversary. That could be someone internally, someone on the board, an officer in a membership corporation, a member who's suing for breach of fiduciary duty. Again, it could be the attorney general or a regulator who's raising concerns. and will take and run. Will take these missteps and run with them. And so when you have these fundamental missteps, like the notice of the meeting was inadequate, um, like you didn't hit quorum, like you ignored other provisions in your bylaws, like the conflict of interest requirements under the statute and under your policy were not met, the argument that you're going to get is that the decisions you took and the actions and expenditures that you made were not properly authorized. And we've seen multiple instances over the years where there's an assertion by whoever the adversary is that the board members personally need to put back the funds that they thought they approved as expenditures because the approval was inadequate and therefore the expenditure was unauthorized. So keeping your eye on the process and procedure ball and this level of detail is necessary and essential to protect the organization and, in fact, and we're going to get into this in a minute, to protect the individual board members and officers personally. So it's about 10 minutes in, actually, about 11 and a half. And I don't know if this is a record. My clients have a running joke that, it's only a couple of minutes into any conversation with me before the words fiduciary duties get mentioned. And so, I don't know, maybe this is a record 11 and a half minutes or so. And I think I said it earlier, but we can look back at the video and see. But let's talk about some governance fundamentals. And in particular, let's review the core fiduciary duties of nonprofit board members and officers. And here are the fundamental precepts. First, that directors of nonprofits have legal duties, which we call fiduciary duties. And here's the 800-pound gorilla, that there can be there can be personal liability to directors for breaching these legal duties. That is something that is a little bit counterintuitive and can come as a surprise. And so I'm glad you're here and hearing it today, because that means it will never come as a surprise to you. It's quite unfortunate when this comes as a surprise to board members, and officers, but you can understand why they might be surprised, because it is a little counterintuitive. So here I am. I'm a nonprofit board member. I'm a volunteer. I don't get paid. I might also be a contributor, donor to the organization. And yet, for all of that, what do I get? I get a lawsuit and potential personal liability. So it seems a little counterintuitive. Whether it is or not really doesn't matter, because it's the law. So there are three fundamental fiduciary duties of a nonprofit director and officer under New York law. And the three are the duty of care, the duty of loyalty, and the duty of obedience. And we are going to unpack those because they are just incredibly important. The duty of care requires, and this is actually in section 717A of the not-for-profit corporation law, that a director must discharge the duties of his or her position in good faith and with the care that an ordinarily prudent person in a like position would exercise under similar circumstances. So that language is incredibly important. What it tells you right away, it sort of debunks the myth that, well, if I do the best I can, particularly under difficult circumstances, that's enough. After all, I'm a volunteer and I'm not a lawyer. And even if I am a lawyer, the same duty applies to me. So that's not the standard. The standard is to act in good faith and with the care that an ordinarily prudent person in a similar position would exercise under similar circumstances. And what is this? It's basically the oversight function. It requires ongoing oversight. And again, if we have time, hopefully we'll get into that a little more. It requires familiarity with the organization's finances and activities and regular participation in its governance. So if I'm on a board, and there are 6 meetings a year, and I come to one, um, that is not appropriate exercise of my duty of care. That is not appropriate oversight, and that is not regular participation in the organization's governance. If I never read the financial statements or anything else that gets sent to me in advance of board meetings, again, penalty flag. That is not oversight, and it's not regular familiarity with the organization's finances. So in your materials that I've included with the seminar are is the Healing Arts Initiative lawsuit from about 10 years ago. And the Healing Arts Initiative was a nonprofit in Queens. And the big takeaway here is if you look at the defendants, you see lots of individual names, and those were all of the members of the board of directors, and they got sued personally. And what did they get sued for? We won't spend a lot of time on this. We'll go through it quickly, but you can look in more detail in the materials that are attached. They got sued for breaching their duty of care in violation of the not-for-profit corporation law, the section we talked about, and another section. They violated their duties. They didn't, and look at that language right from the statute. They didn't act in good faith and with the care an ordinarily prudent person in like position would exercise in similar circumstances. So there it is, quote unquote, directly from the statute. And here the allegations were, and this is the summons that initiated the lawsuit that we've attached in the materials. They didn't exercise care in their oversight by permitting $750,000 to be stolen by 3 former employees, by hiring non-independent auditors, and negligently hiring employees and otherwise breaching their duties. And for their alleged breach of fiduciary duty, they were each sued for $750,000 plus attorney's fees plus punitive damages, and the lawsuit asked for the removal of the board. So some other materials that you're going to be getting relating to the duty of care, we'll touch on here right from the start. And if you've met me, if you're on a board that I represent, if you're employed by a nonprofit that I represent, or if you've been to a seminar or a webinar that I've done, you'll know that I'm very big on right from the start. Subtitled Responsibilities of Directors of Not-for-Profit Corporations. It's a publication by the Attorney General's Charities Bureau. It's very accessible in that it's written for non-lawyers, about 9 pages long, and I suggest that my clients read it literally every year to remind themselves of their fiduciary duties. And in particular, this publication spends a decent amount of time on the duty of care. You're going to also get a copy of the lawsuit in the Adelphi University matter, which goes into, it's a lot longer. It's a decision in that matter, and it goes into a lot more detail and is a lot more lengthy than right from the start. But you're welcome to take a look at it, and it goes into also the duty of care, goes into conflicts of interest and similar missteps by the board of Adelphi University at the time. A very important litigation from a few years ago, which if we have time, we'll get into today. If not, you should read through the section of the PowerPoint, which you'll also get a copy of, that deals with this lawsuit, the Dowling College lawsuit. And I should mention that the PowerPoint is written more like an outline. So even if we don't cover something, if you read through the PowerPoint, you probably will understand what's behind each slide, and you will also have the materials that we're talking about here and some others to look at. The Dowling lawsuit, there again, 13 individuals were sued, and again, you can guess who they were. They were everyone on the board of directors, plus also the CFO. They were all sued personally. This time, as opposed to Healing Arts. It wasn't for $750,000. It was for $50 million each. Um, and they were sued for breach of fiduciary duty. And what is included in your materials is a copy of that complaint. And the complaint goes into detail about what the alleged breaches of fiduciary duty were, and it's incredibly illuminating and informative to read that. Internal controls are quite important, and that's something, internal controls, policies and procedures, that's something that your accounting firm should be helping you with. We do a lot of work with Cerini Associates, and they're incredibly helpful to our clients in the area of establishing and maintaining proper internal controls and policies and procedures. And there's also an Attorney General guidance document, internal controls and financial accountability for nonprofit boards, and that is being included in your materials. And then I want to give a nod to the critical role of audit oversight. And you're also getting the Attorney General guidance document, audit committee requirements and responsibilities under the not-for-profit corporation law. And what I will mention is that there is only one committee with an entire section of the not-for-profit corporation law dedicated to it, and that is the audit committee. And that tells you how critically important the audit oversight function is. And I should also note that if you don't have an audit committee, but are required under New York law to have audited financials and submit those to the Attorney General, then the entire board, but only the independent directors on the board, has the audit oversight responsibility. So one way or another, if you're required to submit an audit to the Charities Bureau, either the board or the audit committee has to fulfill these audit oversight responsibilities, and they are incredibly far-reaching. And I highly recommend that you focus on them. When we draft bylaws for our clients, because these are so important, we include them verbatim in the bylaws. The entire audit oversight responsibility section of the statute we put in the bylaws because we want that to be front and center in the client's consciousness at all times. So that's a critically important item of governance for you all to focus on. So that concludes the duty of care, and I'm going to move on to the duty of loyalty. And again, I really encourage you to put questions in the chat, and I will get them from our hosts at Cerini and respond to you after the program. So what's the duty of loyalty? This requires that a director must act in the interests of the organization. Seems rational, but here too, it may be a little more far-reaching than meets the eye because it requires an undivided allegiance to the organization's mission when using the power of a director's position or information concerning the organization or its property. The main area that we see the duty of loyalty play out is in conflicts of interest and related party transactions. And again, the conflict of interest part of the not-for-profit corporation law, which is not just the specific sections devoted to conflict of interest, but extensive definitions in the definition section that relate to those to those conflict of interest and related party transaction provisions, is really a core part of New York nonprofit governance, and it's all mandatory, and so it's not something that can be ignored or altered. So the duty of obedience, that is the third fiduciary duty. We have the duty of care, the duty of loyalty, and now the duty of obedience. And this is the least understood and most often neglected of the three primary legal duties. And my theory as to why is that the other two primary legal duties, duty of care, duty of loyalty, exist in the for-profit world, but the duty of obedience is strictly a not-for-profit law concept. And it is what it sounds like. It's to ensure that the organization complies with applicable laws and regulations and with its internal governance documents and policies. So that's a sentence, but if you stop and think about how broad the implications of that sentence are, it's pretty impressive in terms of the scope of this duty. Um, for instance, um, compliance with applicable laws and regulations is even more difficult than it sounds because there are in fact, multiple layers of laws and regulations. And just for instance, this came up at a board meeting with a client earlier today, lobbying law. There are federal laws on lobbying, there are state laws on lobbying, and there are local laws on lobbying. And you're not going to be surprised by the next thing I'm going to say. They are far from identical. So they cover the same ground, but with some significant differences. And so if your organization engages in lobbying, then you need to be cognizant of all of those layers and need to get appropriate legal advice in terms of compliance. And missteps here can cause all kinds of problems, including jeopardizing your organization's tax exemption. So the duty of obedience, the compliance of law and regulations prong, obviously right at the center of that is the not-for-profit corporation law, which is the New York law that governs nonprofits. Of course, as we said, there are additional layers of laws and regulations, but let's focus on the not-for-profit corporation law for a minute. And welcome to my world because I don't just focus on it for a minute, I focus on it every day. Um, one of the key takeaways here is that the standard is not best efforts under difficult circumstances. It's not that I'm a volunteer and I'm doing my best. This is a law. There are many mandatory requirements and many mandatory procedures. These mandatory provisions are not changeable and waivable. They're mandatory. Um, they don't move. They're rigid. They are bright lines. They're inflexible and they're unforgiving. Some of you may have heard my just sort of it takes us back to a recent very difficult time for all of us. My cemetery, real life cemetery pandemic example in New York. Cemeteries that are not owned by religious orders are required to be not for profit. So there are quite a number of New York cemeteries that fit that mold and that are nonprofits. And I have a bunch of cemetery clients. And during the pandemic, um, one of them called me in a panic. I, at the time, myself happened to have COVID. So it was it was just not a happy time. And they told me that they have refrigerator trucks with COVID victims lined up outside the gate to the cemetery down the road. Um, and they're overwhelmed. Their employees are terrified. Some of them are out sick. Others are afraid to come to work. And the ones who are coming to work are incredibly stressed. Um, and they can't get any state agency to give them a waiver of the requirement that they hold their annual meeting in June, on a certain date in June, which is in their certificate of incorporation as required for cemeteries under the not-for-profit corporation law. So, why couldn't they get any state regulator, including the Division of Cemeteries, including the Attorney General's office, to give them a waiver? Because nobody has the authority to give a waiver of a law. The law says that cemeteries have to give the month and day of the week of their annual meeting and needs to be in their certificate of incorporation, and they have to hold their annual meeting on that date, period. So the short answer is, of course, this cemetery did not hold its annual meeting on the required date. But it wasn't because the law was flexible and allowed them to sidestep the legal requirement. So the key aspects of the duty of obedience in terms of the internal governance documents are the certificate of incorporation and the bylaws. The duty of obedience requires literally obedience to those documents. So again, your corporate purposes, you need to follow them, obedience, obey them. The provisions in your bylaws, same thing. They need to be followed and obeyed, if we take the word literally. So the compliance with the certificate of incorporation, the principle there is, again, your purposes of your corporation are stated directly in the certificate of incorporation. And the legal principle is that a diversion from corporate purposes, no matter how worthy, is a breach of fiduciary duty. And this is one of the central oversight functions of directors and officers. It's the use of assets consistent with the purposes in the certificate of incorporation. The entity has purposes. You are the gatekeeper, and you are required to make sure that the assets are used only consistent with those assets. Now, those purposes can be amended. There's a legal process to do that, and there are lots of procedures and requirements around that. And that's something we can talk about offline if you'd like to. I won't get into that here. But that doesn't change the bedrock principle. What my certificate of incorporation says my purposes are today, those are my purposes, and it's my responsibility as director or officer to obey those purposes, again, duty of obedience, and and to make sure that corporate assets are used only to fulfill those purposes. And so, again, no matter how worthy the project, if it doesn't fall within our purposes, we can't do it. I got a phone call at the height of the pandemic from an accountant who had a nonprofit client that had started a wonderful new program in response to the pandemic. The program addressed food insecurity and food needs in the community where that nonprofit was located. One problem, and a big one, and a fundamental one that could not be evaded. This activity, though vitally important, fell outside the purposes set forth in the certificate of incorporation. So even though it was necessary, even though it was worthy, it was a breach of fiduciary duty, and everyone on the board and every officer had personal liability for essentially misusing the assets in a way that didn't comply with the corporate purposes. Again, the principle, a diversion from corporate assets, no matter how worthy, is a breach of fiduciary duty with potential personal liability to board members. So another phone call at the height of the pandemic from a concerned board member of a client, a nonprofit that was not a client of ours, but had this board member had gotten an email from the board chair, and the board member was a little suspicious, and with good reason, because the chair states in the email that while normally the board would have a meeting to vote on nominations, because of the pandemic, the board would vote by email instead. Now, again, take a step back out of the world of nonprofit governance. That doesn't sound like a crazy proposition. There's a pandemic, we can't meet in person. Normally we would, but because of the pandemic, we can't, we won't. So let's vote by email. Sounds rational, but um, email voting by the board of directors of a New York not-for-profit corporation is an impermissible shortcut, and you need to avoid that. There are only two ways for the board to act under the law. Number one, at a meeting, which can be in person, by conference call, or by video conference, or by a hybrid of those. And so that's the first way that a board can act, at a meeting. The only other way for a board to act is by unanimous consent in lieu of a meeting. And that unanimous consent can be either written, where each director signs, or by email, where each board member signs, emails their consent. So the key here, again, a little bit counterintuitive. If I've got 50 directors and I want to act without a meeting, I can't collect 49 consents. I need all 50. If we're acting without a meeting, it must be by unanimous consent. And here the effects of missteps are that board decisions can be invalidated, and there is potential personal liability for board members in those situations. So let's talk about documenting corporate action and corporate compliance. As I think is clear by now, there is no dispensation for extraordinary circumstances. Um, there are requirements, they need to be followed, and they need to be documented. And minutes again are critically important. Too much detail can be a problem. I don't like transcribing minutes. Um, uh, uh, Too little detail is an even bigger problem. Uh, and the way I like to look at minutes, of course, they have to report and record uh, for the record what happened at the meeting. But when you look at the minutes in reviewing them, um, they should really be a checklist to demonstrate that the board has fulfilled its fiduciary duties. So when I look at the minutes, I should say, here the board exercised its duty of care. Here the board exercised its duty of obedience. Here the board exercised its duty of loyalty. Um, and again, as you might suspect, conflicts of interest and related party transactions, the compliance with the conflict of interest policy and with the law must be clear from the minutes. And this is, I think I mentioned in the early slides that one of the issues that we've seen a lot of recently that have led to major complications for some nonprofits that have come to us with a bit of a mess on their hands is that their minutes didn't adequately reflect what happened at the meeting. So if the board makes a decision, we had one instance where a board thought it adopted and probably did adopt a conflict of interest policy that complied with New York law, um, but the minutes didn't reflect it. The minutes weren't clear on the fact that the policy was adopted, and that led to quite a bunch of complications in an internal dispute later on. So the minutes are not something to be given short shrift. They really are critical to demonstrate that the board fulfilled its fiduciary duties, and the effects of missteps here can be quite far-reaching. Again, breach of fiduciary duty, uh, internal disputes, potential personal liability, regulatory investigations and entanglements. So, here I think is the first time we're seeing my tagline, nonprofit governance. It's not rocket science. It isn't. Nothing that I've spoken about so far is anything close to rocket science, but for sure, it takes significant effort and significant attention to detail, but there's no way around that. So what we see is that what's required is lots of process, following lots of procedures, being cognizant of mandatory requirements that we can't modify. There's some provisions of the law that you can customize and you can modify, with sometimes within limits. So there are limits on the minimum quorum that a board can have. But if you follow that minimum, you can customize and modify quorum. But there's some requirements that are mandatory and that can't be modified an iota. And as you might imagine, it is essential that your bylaws track those mandatory provisions and that you as a board are aware of what's in your bylaws and what's in the law and what's mandatory and what you must follow. And on that note, board education is essential. Um, it's not hard to see that no board can do this on its own. I have clients that are lawyers' organizations, and everyone on the board is, by definition, a lawyer, and they still need board education. They still need someone to walk them through, even though they're all lawyers, these very specific, very detailed requirements in the not-for-profit corporation law. It requires continual awareness. Again, that's why I give so many pandemic examples. Even under the most extraordinary circumstances, these rules are inflexible. They don't move, they don't bend, and they need to be followed. And obviously, discipline and a commitment to compliance. So the bylaws, let's talk for a minute about the bylaws. They're basically a contract between the organization and the board as to how the organization will operate. They're rules by which legitimate corporate decisions are made, and following these rules is a roadmap to protect the directors from breach of fiduciary duty allegations. Always follow the roadmap that the bylaws provide. Make sure that the bylaws are consistent with the law. That's important because, again, you can have, and I see this all the time, new clients walk in our door, they show me their bylaws, and they've been following them religiously for years, sometimes decades, except their bylaws, though rational, and one can understand why someone adopted those provisions and wrote them back in the day, they are completely inconsistent with the requirements of New York law on specific points. So make sure that those bylaws are consistent with the law. Failure to strictly adhere to the bylaws or having bylaws that are inconsistent with the law is a breach of the duty of obedience. You probably all said that together with me. Um, Consequences can include undermining the validity of corporate decisions and actions. And here too, governance mistakes in these areas are another potential trap for directors. Decisions of the board can be challenged as illegitimate, and it can lead to breach of duty and personal liability for directors. Again, not rocket science, but high stakes. Um, Committees are another area of the law that have lots of specific requirements. I'm actually going to skip this because I want to talk a little bit about um, the Dowling College litigation from a number of years ago. And again, you can read through the uh, the outline, and you'll think be able to understand pretty much everything that's there. Call me if you have questions. What I want to highlight about Dowling is um, when you look at what the lawsuit is about, the essential premise of the Dowling litigation is that the board members had a fiduciary duty to have adequate information. They did not get adequate information. It was their responsibility to get that information. So my key takeaway that we all need to think about here, because again, here's a situation where each of the board members was sued personally, as well as the CFO. Um, Timely, reliable, and accurate information is required to support adequate and informed oversight and decision-making by the board of directors, and by the officers. This is not something that the board and the officers can be relaxed about. It is an affirmative responsibility. If you're not getting this information, you have to demand it. The board has affirmative responsibilities to get information that would allow it to manage and conduct oversight and fulfill its fiduciary duties. And the board in Dowling did not do that. They got data that was incomplete and unreliable. It didn't enable the college to adequately conduct its financial reporting and analysis. And the result was that the board and administration didn't have the tools to evaluate the college's financial position or to make informed decisions. And that led to Dowling's loss of accreditation, its bankruptcy, and ultimately to the college closing and to the directors getting sued personally. So that's something to very much keep in the forefront of one's consciousness. If you're a director of a nonprofit, you are required to have current and sufficient information to conduct the oversight that is required of you under the duty of care. And with that, I want to thank you for being here. I really encourage you to either post questions in the chat and I will get back to you, or to email me directly with questions. And I'd love to talk to you and continue this further offline. Thanks very much.